Thanks, Phil and Jason, everyone at the Geneva Network and the Free Market Foundation. Really appreciate the invitation and the opportunity to speak with all of you. I'm Patrick Kilbride. As Phil said, I'm with the U.S. Chamber of Commerce, part of our Global Intellectual Property Center, which is a division of the Chamber focused exclusively on driving, driving the factors that produce innovation and creativity in the marketplace. And what I want to say, first of all, is innovation is everywhere. You know, some of the most innovative people we see are children playing in the street. You can give them a ball or a stick or a piece of rope or nothing at all, and they'll come up with ways to play together, to entertain themselves, and really astonish us with their creativity and their innovation. So when we say that one country is more innovative than another, we don't mean that the people are more or less innovative. What we mean is that they've established an infrastructure that enables the ideas that all of us inherently have, and to turn them into successful products that can actually reach and benefit others in a consistent manner. That they've sort of figured out the process of taking those root ideas and turning them into usable products and services and technologies. And that's what intellectual property law is ultimately all about. How do we create the infrastructure to empower our citizens to take their creativity and to make it useful to everyone? So that's what we do at the U.S. Chamber of Commerce at the Global Intellectual Property Center, is we look at the intellectual property laws in place in the United States and in countries around the world, and we talk with governments about how they can use that platform to make the most of their opportunities at home, to innovate in the domestic economy, and how they can best improve their access to the world's innovation. One of the tools we've developed to do that is the U.S. Chamber's International IP Index, and that's what I'd like to talk to you about today. And so, at the risk of death by a PowerPoint, I'm just going to walk you through a few slides that give some of the details. And are we advancing here? Or?
That's on the screen yet.
All right.
Sorry about that.
Yeah, no problem.
Technical hiccup.
Thank you very much. Appreciate it, Jason. So, sorry, arrow down?
Yeah, I'll cross.
Okay, great. Okay, so first of all, this index, I'll give you, there's a few copies. I have a few copies for anyone who's interested, and there's a one-pager that describes it on the tables. But this is our International IP Index in its 5th edition for 2017. We began this project in 2012, looking at 11 countries across 25 indicators. In over 5 editions, we've grown the index now to 45 economies and 35 indicators, accounting for about 90% altogether of the global economy. Those 35 indicators are each given an equal weight of 1 point apiece. And so across 6 different categories of IP protection: patents, copyrights, trademarks, trade secrets and market access, enforcement, and participation in international treaties. It gives you a fairly comprehensive, certainly not exhaustive view of the intellectual property landscape in any given country. So what is that national IP environment, and why should we measure it? Let me take the second part first. Why do we measure? It's because, as our business leaders always tell us, if we can't measure it, we can't improve it. And as we looked at the landscape of literature about intellectual property and innovation, we saw that there was a vacuum here, that there were plenty of academic papers about discrete aspects of intellectual property law, be it copyrights or trademarks or esoteric aspects of patent law, but there was really a need for a comprehensive metric where you could look at a country's IP landscape across the board and understand what it looked like and how it compared to that in other countries. So first of all, we look at the legislation and regulation. What are the laws on the books? What are the rules that have implemented them? We look at whether those rules are enforced. And finally, we look at the general political attitude towards intellectual property. Is the government fostering an environment in which innovators, creators, and the users of those products have a high degree of legal certainty as to what the rules are and how they'll be applied in practice? What's changed? We look at the context for a country's IPR environment in terms of what other countries are doing, what the global marketplace looks like. And, we're in a position now where we have the WTO's, the World Trade Organization's TRIPS agreement, the Agreement on Trade-Related Aspects of Intellectual Property Rights, now in place for more than 20 years. And so that's been an opportunity to develop a much better understanding of how countries are approaching IP. In the pre-TRIPS environment, it was very scattershot. Few countries had a comprehensive IP framework, and there were few, if any, international obligations to do so. Now, in the post-TRIPS environment, we can finally take a look at what the impact of intellectual property is. And so the OECD has done an important studies, for instance, on the connections between intellectual property and R&D expenditure in the domestic market, trade and services in the development of knowledge capital, and importantly, foreign direct investment, and shown a very direct relationship between strong IP environment and those beneficial outcomes. And as I'll talk about in a moment, we've tried to take that idea a step further through this index. So what do? What we have here is not a survey. We don't go around and ask pharmaceutical companies or filmmakers or authors about how they think China or India or South Africa is doing in terms of IP. That kind of anecdotal evidence is useful, but it's not empirical. So what we set out to do was to create a fairly rigorous metric that actually looks at what the rules are and how they're enforced in any given country, and then to be able to enable global comparisons on a like-for-like basis. And so we reference certain existing international standards. We look at the Global Innovation Index, for instance. We look at the OECD's piracy rates to help inform our index. But then principally what we're looking at is what's happening on the ground in any given country. So first of all, we want to have that broad, comprehensive understanding of the IP environment in a given country, but we also want to make it very specific. So as I'll go through in a moment, what we're getting into here is how does a country, in terms of patents, what does it mean to have a strong patent environment? What does it mean to have a copyright environment that enables investment of time, of energy by authors and entrepreneurs, and what does that look like? And what we found is that there truly is a rigorous debate, a robust debate going on internationally about the very, the purpose and effectiveness of intellectual property laws. And what we're finding is that there's a real divide here between people who want to see intellectual property as something that comes after innovation, in effect working as a tax on innovation, and something, as we believe, that actually acts as a catalyst for innovation. So it's not innovation plus IP equals cost, it's IP plus innovation equals output. And this is the debate that we're having around the world at the OECD, at the G7, at the World Trade Organization, and even at multilateral organizations like the World Health Organization. And countries like South Africa are having an important impact on what that debate looks like. And we want to make sure that as that debate takes place, it's as well informed as it can possibly be. Now, as this index has grown, as I described, we've been able to grow both the scope in terms of the countries that are included, where now we have 90% of global GDP and most of the major markets in the world accounted for, but also that we're keeping it at the cutting edge in terms of what's measured. So this year, for instance, we added indicators on patent opposition, on industrial design, on barriers to the commercialization of IP, which we think is an incredibly important aspect of how countries create a successful IP model in their own market, and things like transparency and public reporting. So just to give you, again, a sense before I get into the specific indicators, each one's given equal weight for a total score of, a possible score of 35 points. There's 6 categories, which are roughly evenly weighted. We have about 7 indicators in the patent space, 7 for copyright, 7 for trademark, and then so on and so forth. And the indicators can be binary, that is a 0 or a 1, for instance, or they can be mixed. You can get a percentage score. And here, just to give you a sense of the discrete indicators that the index measures, these are the patent and copyright categories. And what you'll see is a structure. So the first indicator is on patent term of protection, and there's established international norm of 20 years. And in fact, virtually every country on the index scores a 1 for this indicator. Only Venezuela, among the countries measured, fails to provide a 20-year term of patent protection. So 44 out of 45 countries get a full point, a 1, on that first indicator, and we also, but then on a fairly even basis. But then you can quickly see how it changes from there. You get into patentability requirements, and the WTO TRIPS agreement requires a 3-step test of novelty, non-obviousness, and usefulness, terms that are defined in international law. And when countries go beyond those basic terms or exceed the definition to restrict patentability, then they lose points on our index. But more importantly, they restrict the ability of innovators in their market to take advantage of the patent term as an incentive to invest in innovation. And from there, you'll see other indicators that relate to the legal certainty in the marketplace. So for instance, indicator on patent term restoration goes to the question of whether a country provides an ability to make up for a term that is lost due to regulatory delays in the approval process. The same can be found in the copyright and trademark categories, where we're establishing, first of all, that there's a basic level of protection, and then how that protection is enforced so that the innovator, the creator, can benefit from their full patent term with certainty, because this, I would argue, is precisely what enables investment of time, of energy, of capital, all of which is fungible. In any market, investors need to decide how they're going to use their money. And I would strongly argue that they're only going to invest their money in innovative activities, which are inherently high risk when there's a high degree of legal certainty. Finally, we get into trade secrets and market access, or trade secrets protected in law, which is a developing international space. Is there protection for regulatory data that's submitted, or for clinical trials, for instance? How are these laws on the books enforced? What are the physical counterfeiting rates in a given economy? What are the rates of online piracy? Does the government itself require its own agencies to use registered software? These all form a part of the index. And then finally, and I think very importantly, we look at a country's participation in international treaty making, because this is how we work together to shape the global environment for innovation. Is through, and so we've included 4 sets of treaties that look at the cutting edge. What are what's setting the rules for tomorrow for the global IP space. So things like the WIPO Internet Treaties, Singapore Treaty on the Law of Trademarks, Patent Law Treaty, and participation in at least one cutting-edge trade agreement that helps to push the model forward. Our sources, based on both qualitative and quantitative evidence, that is, some of it would be obvious to anyone looking at it, okay, this law is present or it's not. In some cases, our researchers who are independent of the chamber are required to make some judgment calls. They draw evidence from as wide a range of sources as possible. The one requirement is that everything they look at has to be available in the public domain. So we look at government laws and regulations on the books. We look at committee reports from parliaments and congresses. We look at patenting guidelines, for instance. We also look at court decisions, legal opinions, and analysis. We look at third-party reports, whether it's from the World Bank or the WTO or the OECD, academic publications, as well as, where relevant to help inform all that and enable those judgment calls, news reports, and analysis. And this year, for the first time, you can find all of those sources on the U.S. Chamber's website. Our researchers looked at 5,000 separate sources in the compilation of this index, and you can see it broken down by country. We have also, over 5 years in developing a conversation about this index, encouraged governments to provide detailed submissions. And in fact, more and more of them have every year. I think this year we had more than 30 submissions, some of them dozens of pages long, helping us understand how they think they perform against these indicators and filling in some important blanks. And again, the only criteria was that they have to be publicly available on the record. So what are the results of all this? This is, with 45 economies, it gets very difficult to see. But what you can see, first of all, is that there's a wide discrepancy between the lowest scoring countries and the highest scoring countries. Scores ranging from 6 to all the way up to 32 out of 35 points. So no country gets a full score, no country gets a perfect score, but there's a segment of them in the top 5 or 6 or so that come very close. And then there's that wide white space above the top that I consider the opportunity index, because that is the area where countries really have an opportunity to empower their own innovators and creators and to create better conditions. And what we hope is that the index actually provides a bit of a roadmap for them to do that by showing point by point in the patent space, in the copyright space, in the trademark space, what are the mechanisms that business is looking for in order to invest in their market, whether it's domestic innovators or whether it's foreign investors. The other takeaway that I want you to take from this is that no two countries score alike. And across 35 indicators, and a wide range in between, percentage-wise, you might think that 20 years after the TRIPS agreement that there would be one cluster of countries at the bottom, straight line across, maybe leaving aside the fact that the least developed countries continue to have certain waivers in place. But you might expect to see much more uniformity with these countries that are pushing so-called TRIPS plus policy disciplines, perhaps exceeding that. That's not the case at all. 20 years after TRIPS, what you see is 45 different IP profiles. And even countries that are very close together in score may have completely different profiles in terms of how they treat copyright, how they treat trademark, how they treat patents. So for instance, Brazil and South Africa are grouped very closely. They're 32 and 33 respectively out of 45 countries. But one does better in patents, one does better in copyrights, one does better in enforcement. So they actually have a very different profile that they present to innovators in their markets. And as we'll go through in a moment, those policy choices matter. So, even in a post-TRIPS environment, the IP framework in any given country is being actively shaped by the independent sovereign policy choices that governments are making, and they're all making different choices. So why does it matter? As I mentioned earlier, the OECD has done work on the rates of FDI related to intellectual property strength, on technology transfer, innovation, economic development. Well, I think we all sort of understand intuitively how intellectual property drives some of these outcomes. But for the most part, we haven't done a good job of capturing that and cataloging those beneficial outcomes. So beginning in our 2014 edition, we made an effort through this index to make some correlations between IP strength on the one hand and socioeconomic outcomes that all governments desire for their citizens on the other. And I'm going to walk you through a few of those. We go through 21 of them in the current edition, and we've actually related them this year for the first time to an innovation life cycle. So looking at the relationship between IP strength on the one hand and the resources dedicated to innovation. So the development of human capital, the amount of private sector spending on research and development, as well, second, as actual creative activities. What's any given country's output look like, and how does it compare to other countries? Third, how does a given market access technology? And fourth and finally, what are the dynamic economic benefits of having a strong IP framework in terms of job creation, in terms of foreign direct investment, and other factors. So to give you just a few examples, first of all, this first correlation, very strong at 0.70, is between IP strength and private sector R&D spending for that economy. Second, IP and its relationship to innovative output as measured by the Global Innovation Index. And again, an even stronger correlation here at 0.88. Next, we see the relationship between IP strength and high-value job creation. And this is jobs in research and development, jobs in cutting-edge industries, the kind of human capital that countries need to be effective participants in the knowledge economy. This one relates to clinical research, which is, of course, incredibly important to drive attention by innovators to the particular challenges in a given market. So if you have, for instance, neglected diseases or other conditions that are a bigger problem for your market than others, but you have a very weak clinical trial presence, then we're not doing a good job of addressing that market-specific needs. IP can help ensure that attention takes place. Access to advanced technologies. We can show that as countries invest in a stronger IP framework, they have better access to the newest technologies, products, and services. And that makes sense, doesn't it? If you think about an innovator's point of view, they're bringing products to market because they want to sell them. They want to make them available to consumers, and they're looking for markets where they can deliver that product with some assurance that there will be a return on their investment. So they're going to go first to those markets that provide a strong degree of protection for their intellectual property. And finally, and to me this is one of the most important, this was one of the most exciting correlations we did, the relationship between strong IP and access to venture capital. And while we look specifically at the question of venture capital, because that's so much in everybody's minds in terms of startups, I think the same point is equally applicable to bank collateral, to collateral for bank loans for a small business. At the multinational level, for a multinational company to be able to exercise its fiduciary responsibility to report the value of its assets accurately to shareholders, they need to have good information about the value of their IP. And countries strengthen that knowledge when they provide a market with a high degree of legal certainty. You know, if a company has to diminish the value that it reports to shareholders of its patent holdings, for instance, that's going to have a negative effect on its ability to bring new capital for innovation. So across the board, whether it's a startup, a small business, or a large multinational company, they all benefit from the legal certainty that comes from a strong IP environment. Finally, along with the rankings, the country reports, and there's several pages in the index for each country that's ranked of analysis, we also do, for each edition it's been a little bit different, but we do some accompanying analysis. So for instance, last year we looked at how countries performed in each of the categories. So you could look in detail about how South Africa did in the copyright space versus its peers. You could look at the same for patents, trademarks. This year what we did that I thought was sort of interesting, we looked at the TRIPS agreement and trade agreements and asked the researchers to help us benchmark those against the index. So on an index that's worth 35 points in total, we said if a country did the minimum necessary to implement TRIPS, what would they score? And they came up with a score of 15.5 points. Then we asked them to do the same for the then pending Trans-Pacific Partnership Agreement. If I talk any more about the TPP, I might cry in front of you. I don't want to do that. TPP scored 25 out of 35 points. And I think what this shows is that treaties and trade agreements are helping to advance the benchmark internationally, but they're not to the top yet, and they're not getting they're not putting in a strong enough model to really fully empower innovators in any country. We need each country to make a sovereign policy choice that it wants to invest in its own market for domestic innovation. And finally, this year we added some specific zoom-ins. It's almost like a blog in a sense. We're using the index, trying to keep it as a living document so that over time we can invite outside voices to look at the results, help us draw conclusions, and then publish some findings about them. And we're doing that in a collaborative fashion with various people. This year, we did one specifically on Canada and another on licensing and commercialization of IP. And that's an area where we'd love to collaborate with stakeholders around the world. You know, if you have perspectives that you would like to share in relation to the findings here, then we can help to put that out. I mentioned that already. So finally, what I want to leave you with, each country, as we saw, is making its own choices. Those choices matter because they have a specific effect on innovative output, on job creation, knowledge-intensive industries, access to innovation. So these choices matter, and yet there's a long way for most countries to go to reach the level that that the leading countries are setting. And we can show that as countries walk themselves up this ladder, they're seeing the socioeconomic benefits that they want to see. So our hope is that this index provides a platform for a dialogue. Want you to engage with us. The index is available on the website. It's uschamber.com/IP index. We're also on Twitter and Facebook and LinkedIn. And we're hoping that this can be the basis for an ongoing conversation, that we can help to inform IP decisions not only here in South Africa but around the world by providing a global context. And so, while I would never presume, as someone from Washington to tell you you should do this or you should do that in terms of compulsory licenses or forced localization or patentability of software or whatever the case may be, I do want to be in a position to help you understand how South Africa's decisions relate to the decisions of the Chinese or the Brazilians or the British, and what the implications of those different policy choices are. And so that's our hope for this index, is that we can help to inform that environment. So I look forward to the other presentations and to any questions or comments you might have. Thank you.